I was in shock when she was trying to explain why it was that she didn't call 911. Why instead of immediately calling 911, she did many other things. We know that she called the neighbor fireman 8 or 9 times. We know that she tried to call his wife 8 or 9 times, tried to call him. We know that she went on her iCloud. She found his number before she called him. We know that she called her husband. We know that her husband told her to call 911, and we know that after he told her to call 911, that she tried to call the neighbor fireman once or twice more. Why? Why, given all of the early childhood education that she had had in schooling, why, given her first aid experience, given her CPR experience, given all of her experience as a foster mother, as a babysitter, as a nanny, why do all of that instead of calling 911? Because you either know that you've done something bad and you're hoping on hope that it goes away or that it somehow fixes itself. Or you realize the circumstances you're in are spooling out of control and you're trying to figure out what to do. Dr. Vercruci talked to you about how a child who has, or anyone who has suffered third-degree burns, a couple of things are going to happen. First off, once the burn is that deep, those burns aren't actually painful anymore because the nerves are dead. So it's only going to be those lesser parts of the burn where there's pain. But he also told you that people with third-degree burns are otherwise relatively normal, even when they've been burned over a large portion of the body. He told you about one case where it was almost 100% burned, and the person was coherent, was asking to speak to his wife so that he could have his final words with her. So someone with third-degree burns may not initially, other than the discoloration of the skin, might not appear that abnormal if you're talking to them. But then over time, as time passes, he told you what happens. That fluid loss starts to happen. They start becoming dehydrated. Their skin starts to leatherize. It starts to tighten up. And they drift away. The organs start having difficulty. Circulation to the brain becomes not so great. So over time, they become less verbal, eventually not verbal at all. So given all of this training, why not call 911 immediately? Well, it has to be one of those two. Because what does 911 bring that your neighborhood firefighter doesn't? Or that your husband doesn't? Or that the firefighter's wife doesn't? 911 also brings the police. Or in this case, so instead of calling 911, you try to call the neighborhood firefighter, hoping that he can help fix this situation and there won't be any law enforcement involvement. Maybe you Google searching for baby bath burns or kid bath burns to try to figure out if there is a way to stem the tide of what's going on in front of you. Given all of Miss Osteraas' child care experience, all of her education, all of her training, 911, that's the first thing you do when you realize that your child is burned to any degree from here all the way down to the ground. Unless you've done something bad. She told you what happened. She took the stand and she told you that her mom put her in the bath and would not let her get out. She told you that she held her in the bath with a pink towel. And you have evidence before you of two different things, potentially, that Ms. Osteraas used. You have before you, and it's one that hasn't been shown on the screen yet, but it was introduced today, in her bedroom was her pink and green towel that she called her pink owl towel. I'm going to be mean. And you also have the police called it a purple towel. Ms. Osteraas says it's a purple blanket that belongs to another child, and we can debate whether it's purple or pinkish purple or purplish pink, but that's a possibility as well. I told you why she couldn't get out of that water, because her mom held her in there. Now let's take a look at the jury instructions real quick that the judge just went over with you. If you go 3 pages in, that third page in, not including the cover sheet. That's the one that says the crime of child abuse requires proof that the defendant, under circumstances likely to produce death or serious physical injury, intentionally or knowingly did one of 3 different things. Okay, let's dispense with one thing to start off with. Under circumstances likely to cause death or serious physical injury, there's no question in this case that the circumstances that the person was in were circumstances likely to cause death or serious physical injury. I'm not going to show you the pictures again. I'm not going to show you the picture, but you'll have them. The picture of what shock really looks like. The picture on the floor in the bedroom, reaching her arm up in the air. Ladies and gentlemen, that's what shock looks like. But you saw the photographs, you heard all the testimony about the organ failure, about the dehydration. You heard about all of the medical procedures that she went through, the bereavement, the grafting, the escharotomy, the fasciotomy, all of those things. We're not going to belabor through all of those again. You heard that she's going to have, contractures for the balance of her life, probably. She's going to have medical surgeries to fix that, probably for the balance of her life. And you saw her come in the door, take the stand. You saw the scars on her legs. You saw the scar shirt that she wears underneath her clothing to help with the scarring. So clearly, these are circumstances where she was at risk of death and where she suffered serious physical injury. All right? So we go on. Since we have those circumstances established, the instruction requires that we prove that she intentionally or knowingly did one of 3 things. Now, one thing to note here, the law does not require proof that she intended that these injuries be 3rd-degree burns over 73% of her body. Those are the circumstances. The mental state, the intentionally or knowingly, that applies to the 3 ways in which a person can commit child abuse. Right? The first way that a person can commit child abuse is by causing the child to suffer physical injury. Right? And ladies and gentlemen, that is the one that applies when someone actually causes physical injury to a child. Say, for instance, by putting her in a tub of hot water and holding her there. Because if you flip to the next page, what you're going to see, the 3rd paragraph down, is the definition of physical injury. Physical injury means the impairment of physical condition and includes any skin bruising, bleeding, dehydration, burns, soft tissue swelling, injury to any internal organ, or any physical condition that imperils health or welfare. He's had pretty much every one of those in that laundry list. And it only requires one of those. Okay? So, holding her in hot water and not letting her out, that is causing her to suffer physical injury. But you know what? If you read the bottom part of that page, what it says is you don't all have to agree that it's number one. 4 of you can think it's number 1. 4 of you can think it's number 2. The rest of you can think it's number 3. As long as you all agree that she committed child abuse in one of those 3 ways. So let's talk about number 2 and number 3 real quick. Caused or permitted the person or health of the child to be injured while having care or custody of the child. Care or custody is pretty clear in this case. But kind of the reason why this is here is care or custody changes things. Right? A total stranger has a different sort of duty to the child than someone who has care or custody of the child. If a stranger happens upon a child who is in a very dangerous situation, so say a stranger finds a child who is playing right on the edge of I-10, right? Very dangerous situation for a child to be playing right on the edge of I-10. Now, there may be some moral duty there, but a total stranger doesn't have any legal responsibility to protect that child. But someone who has care or custody does. So if it's a parent, if it's a guardian, if it's a babysitter, there's a duty there. Now, in this case, care or custody is very clear. Samantha Osteraas was adopted mother, and she was clearly taking care of her that day. So, causing or permitting the health of the child to be injured. And then number 3, causing or permitting the child to be placed in a situation where the person or health of the child was endangered. And 2 and 3 are really going to be the ones that the state anticipates you're going to be pondering when you're thinking about count 2 of the indictment. Count 1 told you what her mom did. For count 2, that is the count that pertains to not seeking medical attention in a timely fashion. So what do we know about count 2? We know that the paramedic who showed up from the fire department came in and noticed things that were concerning. To her, this did not seem like a situation where a child had been recently burned. She was concerned about the way the house looked. She was concerned about the way she was not responding, and the way that her hair wasn't as wet as she expected a child's hair to be if she had gotten there immediately after being called by the 911 operator. But we also know that once she got to the hospital, the doctors who saw her had concerns about delay in treatment. You heard from Dr. Jane and Dr. Recrusi and Dr. Crampton. And what they told you is that, well, at least with Dr. Jane and Dr. Recrusi, they have experience dealing with lots of burn cases, especially Dr. Recrusi. Many, many, many burn cases. And they both described for you situations they have had where they know that it took 2 hours for the patient